process improved. And I've learned a lot in the course of considering the various motions that have been brought in this matter. But there are a couple of things here. One is a fairly technical procedural matter, and the other is a strong public policy concern that militate against granting the relief that is requested. First, with the appeal pending under Code of Civil Procedure Section 916, this court lacks jurisdiction to effectively make a completely different ruling than the ruling appealed from in this, what's been styled as a petition that court correct orders denying motions for TRO and injunctions. Again, the appellate court considered the previous order that I had made in terms of whether or not that order would be superseded by an order of the appellate court earlier this week. I think that was on Tuesday. At least that's when it was recorded on Tuesday, and they declined to do that. So the first issue is with the appeal pending. Can I, in fact, make a new and different ruling on the same issue? And my belief and response and the analysis that I've done is that I cannot. I think the filing of that appeal and the prosecution of that appeal deprives the court of the ability to make a new and different ruling from April 23rd, or perhaps it was April 24th that it was actually filed. I think I signed it on the 23rd. And so that's a basis where the relief on a technical legal ground ought to be denied. Even if I could reach the merits of this, because I agree with you that this is a hotly contested issue. I don't want to be deciding things on technical, narrow, procedural grounds. So I've considered the arguments, and the initiative process is grounded on the theory that all government power ultimately resides in the people. And the power, as Whitkin states, is to be liberally construed in favor of its use. This policy cuts in a number of different ways in this case, because the Compassionate Use Act was essentially the use of the initiative process and the will of the voters. Measure G at a local level is a similar kind of thing. The local and the statewide level are somewhat distinguishable in terms of how the impact may take place, but nevertheless, the Constitution reserves the right to the people to propose these initiatives and follow through with them. And the courts there's a judicial policy not to interfere in the initiative process and to use the power of the court to preserve the viability of the initiative process where appropriate. So there's this, again, the public policy militates against granting this relief. Now, the only thing that really has changed in a significant way since the last time that we had a full, hearing or argument on this in April was that the Kelly decision was passed. And interestingly, Kelly does, I think, fairly directly and clearly state that 11362.77 was not constitutionally compliant. It was passed by the legislature, and they say that it amends the Compassionate Use Act. Kelly, of course, is not final, won't be for weeks or substantially longer than that potentially if the Supreme Court grants review. Or if the Attorney General, in fact, petitions for review. We don't know whether any of that's going to take place. But following out your arguments here, the Kelly case would only have application of one of the two operative provisions of Measure B. That would be the limits on use provision, which is the one that refers to the Health and Safety Code, Section 11362.77. And essentially, Measure B, like the Medical Marijuana Act, which was described in the Kelly case, has a severability clause. And the court in Kelly talked about the severability clause, and they upheld it in that case. They found 11362.77 was unconstitutional, but they didn't draw up the whole act. So assuming that the Kelly reasoning holds up and it is an unconstitutional amendment, that is 11362.77 to the Compassionate Use Act, that would have some impact, and maybe a very substantial impact, maybe initiate the limits on use portion of Measure B. That kind of remains to be seen. But hard to see how it has any impact on the repeal of the ordinance, which is based on Measure G, which is the second, or it's the other of two operative sections of Measure B. So here's the basic situation that the court confronts. In view of the judicial policy of liberal construction in favor of the power of the people to utilize the initiative process, the timing considerations of the election being a few days away, given the fact that a post-election challenge is always available, even if the court had jurisdiction at this point to grant the petitioner's request, I think the public policies would require the court to deny it, and if I had discretion to deny it, utilizing those public policies and relying on the spirit and policy of the law, both in the Constitution and in the cases that were cited in the April 23rd order. And even in terms of how the Kelly case talks about the viability or the integrity of the initiative process, at this point, it has to be denied.